All right, good afternoon, and welcome to today's MSHA webinar series from Conn Maciel Carey. We are going to be discussing a mid-year review of MSHA and along with a review of significant cases that are affecting the agency, whether from the Federal Mine Safety and Health Review Commission or from the Federal Circuit. Some interesting cases to note. There's obviously been quite a bit happening in the last 7 months with the government in general, and obviously that has also affected MSHA with the leadership transition, with the changes from the DOJ efforts to streamline the government. We'll touch base on all of that and some of the other elements that we've seen MSHA moving forward with in the last few months, and then turn over to a discussion more on the legal side about some of the changes and how those are maybe taking place, whether through constitutional challenges or challenges to specific MSHA regulations. As usual, my name is Nick Scala, and I'll be one of your presenters here for this webinar today. I am the chair of Conn Maciel Carey's MSHA practice group and a partner in the firm's OSHA practice group, where we represent employers all over the country dealing with the regulators, whether it's the federal regulators or state plans. We represent companies, and in particular on the MSHA side, all over the country dealing with compliance, investigation management, whether that is special investigations, accident investigations, or whistleblower investigations, provide compliance advice to y'all as you move through the process, or do the normal thing that usually comes to mind when you're thinking about an attorney, which is litigate and challenge the citations. We're very proud at CMC to be again ranked by Chambers USA as a Band 1 workplace safety group for OSHA and MSHA, and we're happy here to have you with us here today and talk through this. I'm also excited to introduce, at least for the first time on our standard webinar series, my colleague Emily Toller-Scott. Emily recently joined us a few months ago, and I'll let her introduce herself, but welcome, Emily, and we're happy to have you with us.
Thanks, Nick, and hi, everyone. Very excited to join you today for what I hope will be an interesting and productive discussion of what's been going on with MSHA. As Nick said, I'm Emily Toller-Scott. I'm a senior counsel here at Conn Maciel Carey, joined the firm back in the spring. Before that, I should say that I mostly focus on representing mine operators and contractors in kind of all aspects of their relationship with MSHA, whether that's advising, compliance assistance, and like Nick said, litigating. So before I joined the firm, I spent just over 10 years with the Department of Labor in the Office of the Solicitor. The vast majority of that was spent as an attorney advising MSHA. I was headquartered with MSHA's headquarters in Arlington, now DC. So I worked closely with MSHA HQ on new regulations, setting policy, enforcement policies, and issues that came up from the field. Did a lot of litigation myself, both at trial and on appeal. And I'm excited to bring that experience to assist the employers and companies that we work with here at CMC.
Well, thank you, and we're happy to have you. So you'll hear from Emily here just shortly. She's going to take the lead on the case law discussion and what's happening with the Federal Mine Safety and Health Review Commission as we move throughout the webinar here today. But we'll start off talking about what's happening at MSHA, right? So what are we seeing? What are the updates? Whether it is from leadership or new programs or changes in enforcement, just what have we seen over the course of the last few months? As I mentioned, it has been active. Some of it has gone as we would expect. Other elements have been a bit different than what normally takes place during this transition period. So in terms of leadership, though, right, it's always going to happen when we have a change of administration to administration that we get new politically appointed leadership. MSHA and the Department of Labor are part of the executive branch, and therefore the president gets to make these nominations. I think we've talked about this a good bit throughout the process, but Wayne Palmer is the assistant or the nominated assistant secretary. Wayne has experience at MSHA because he served in the agency during the last Trump administration, where he was the deputy assistant secretary to Dave Zotezalo. Following that, Wayne stayed in industry and was an executive at a national industry association, the Essential Minerals Association, for several years before returning to the government to become the nominee for MSHA by the Trump administration here. Um, Wayne has a good understanding of industry priorities and industry perspective, given his time last time around in the administration and from working at EMA. Um, and he also understands there's a balance that has to be met with advancing MSHA's mission, right? Because it is statutorily and congressionally mandated that we are going to have the twos and fours. They will be out to inspect. So it's often trying to find that balance there and how we push that forward. Now, his nomination has not been confirmed by the full Senate. They have not moved to a vote there, just like they have not with David Keeling on the OSHA side. But he has passed through the Senate Help Committee and has moved through there. So it's really just kind of a wait and see game. I can tell you from a perspective standpoint, you know, when the first Trump administration was in office, then Assistant Secretary Dave Zetezelo, he was not confirmed until late fall of that first year. I believe it was November of 2017. Chris Williamson was not confirmed and put into his position during the Biden administration until early the second year. I believe that was March or April of 2022. So, we're not necessarily behind the normal trend in terms of Wayne's confirmation as Assistant Secretary. And I don't think many people envision there's going to be too much difficulty passing the full Senate. It's just a matter of getting on their agenda. And we saw this also in the first Trump administration when OSHA went the entire time without a confirmed assistant secretary because it just never was placed on the agenda for a vote. There's additional priorities that get in there. The Senate also goes through and approves federal judicial nominations, and at least in the last administration, that was a priority over some of these political appointees. So we don't anticipate that Wayne won't take that role, but we're just in the waiting period right now. And while we're in that waiting period, there are political appointees at MSHA. It is no longer being run by the career folks who always take over in that transition period from administration to administration. Now we have the deputy assistant, James McHugh or Jim McHugh in place. He is also the acting assistant secretary at this point in time, so he is the de facto leader of MSHA until Wayne gets into place. He was appointed in April 2025. He previously worked as an attorney representing the industry out of Charleston, West Virginia, in that mining and construction space. So he is familiar with the agency and has litigated a good many MSHA cases over the time. Previously, he served as a prosecutor, and at some point in his career was with the Marine Corps for a number of years. And he really brings that experience that we typically see in the MSHA leadership, which is interactions with large coal companies. And in particular, he has experience dealing with a lot of the unions out of that part of the country as well. So he is in place. He is now, several months into his role as deputy and acting assistant. And we're starting to see some of those impacts and the kind of the vision of the agency begin to take place. But we'll probably see much more of that occur once we see Wayne confirmed and over there. But given the timeliness of certain aspects, some of the executive orders, we're already starting to see MSHA kind of shift into what their priority might be. And we'll talk about that in a few slides more on the rulemaking front. Lastly, we have a new chief of staff over at MSHA, Julianne Schmidt. She was previously the head CEO and founder of a global event and project firm. She has an engineering degree from the North Dakota School of Engineering and Mines, and experience in environmental matters. I'm not sure. I haven't seen too much that shows that she has a great deal of experience in the mining industry. but seems to have some very good experience just in terms of the management side, which is often what the chief of staff is tasked with. And then also as part of it, her resume says she has a good bit of experience developing training content. And I think we'll see here in a few minutes, that is something that the agency is attempting to prioritize right now with their information hub and some other resources. So she may have a role to play in kind of developing and disseminating those kinds of educational materials. I know that as we've talked about what we would like to see from MSHA as we push forward into this administration, one thing that, operators of any kind around the country, whether independent contractors, production operators, coal, metal, non-metal, whatever it might be, we always want to see more consistency. And there's some things that we can certainly see improvement on. And one of them is just consistency in some training and really guidance material from the agency. And so we've already seen MSHA maybe take a couple baby steps in that direction. Hopefully we'll see them continue to do so and, start really taking an active role in giving compliance and guidance advice that, can maybe hold them and the operators accountable as we move forward. So we'll see how that really begins and continues to take shape there. So for changes at the agency, or maybe, or not, right? Depends how we're looking at that. We've kind of broken down that into a few different areas for you. So one of which is inspections, right? We talked about the fact that inspections are still happening. They are going to continue to happen. MSHA is required to do their twos and fours, and they are working to do that. Now, that is likely more of a struggle for them this year than others because of the number of employees and particularly inspectors and managers that left the agency and took the early retirement for some that was being offered at the beginning of the year. It's often called the fork in the road email. And with that, they lost a good bit of their inspector bandwidth. And we've felt that in other ways, such as, reduced emphasis and reduced focus on EFS activities. Some of the CLRs are either no longer present or some have transitioned back to inspection activities. And we're continuing to see them struggle and kind of shift people and minds into other jurisdictions around the country. There were some changes that we expected that, at least for now, have not taken shape. We're expected to see a pretty significant drop in the budget for MSHA, but right now the Senate kept the levels at the 2025. We have seen that there were a number of inspectors that were originally terminated as probationary employees. They were the new inspectors immediately upon the transition. Many of those, if not all of them, have been hired back, which has helped to bolster MSHA's numbers so that they can complete those twos and fours. We continue to see the inspections taking shape, although maybe not in the same way. MSHA has not at least reported and announced an impact inspection since December of 2024. It's not to say maybe they're not happening in some shape or form, but we're at least not seeing the publication of it. And that's not a surprise because in the first Trump administration, we also saw these impact inspections fall off relatively quickly after the transition took place. And then they were picked up again during the Biden administration. So there's a chance we might not see impacts moving forward. And we have at least not seen the data that they have been continued thus far. The NIOSH changes continue to be an active or somewhat active area. There were research labs closed, as you guys might have seen throughout the process. There were medical surveillance resources closed in Pittsburgh area. And much of that remains closed for now, although there is a lawsuit pending where several individual miners have sued the Department of Health, which is over NIOSH, to reinstate the NIOSH personnel. So we'll keep an eye on that as we move forward. It's an impact, especially when we're looking at the Silica rule, because much of that MSHA relied on NIOSH a great deal for the support to that rule, but also there was an element in there that at one point, operators in the final rule that we have would have to submit their medical surveillance data to NIOSH to be housed in a database that NIOSH was going to create at that point. Obviously, no affirmative steps have been taken in that process, given the changes and the really reduction at NIOSH. So some of those areas are still in flux, and we're still seeing changes there. Another area that we got a lot of publication on with MSHA was that there were mine office closures announced by DOGE, or the Department of Government Efficiency. And initially, there's 34 offices announced that were going to be closed. And I think everyone kind of questioned the reality of being able to do so, and MSHA still being able to carry out its mission. Closing 34 offices would have, it would have almost entirely crippled MSHA's ability to, in any type of efficiency, get back and forth to mines, especially coupled with the requirement that federal employees move back into the office 5 days a week. So as with many things that we saw with DOGE, it was more of a suggestion. They had checked and found offices that were having leases expire. Those were reviewed, and in the end, MSHA decided to close 4 offices, one in West Virginia, 2 in Kentucky, and 1 in Pennsylvania, all mostly almost exclusively serving the coal sector in areas where other offices were nearby and could rehome those inspectors and continue to service the mines that remained in that area. So far cry from 34, but we did see some offices close as a result of that effort. And then kind of lastly, on the enforcement side, we had pattern of violations. This, again, somewhat like impact inspections, largely was not a tool used by MSHA during the first Trump administration. We saw them remove the remaining POV mines off of POV during that time period, and then no new mines added. The Biden administration very much wanted to use all the tools in the toolbox, as they would say, and began using POV and put 2 mines on POV during that tenure while they were in office. One of those mines has been removed from POV, and another one remains still, but we really don't expect any new mines to be added on this unless there's some pretty catastrophic levels of enforcement. It's not a tool that we would expect this administration to carry forward on a normal basis, just given the behaviors of the last time that they were in office and controlled the agency. So those are some changes that we have seen and maybe are going to continue to see as we push forward. I did mention that there were some new tools from MSHA that were worth or that have been announced in the last few months. One of them they're calling CASH, or Compliance Assistance and Safety and Health. This is a resource that really it seems a lot like what we would expect from education and field offices and small mines in the past. They are going to provide training resources, safety and health resources, compliance assistance resources to mining companies and new operators, and particularly in small businesses, given the executive orders that have been signed by President Trump that they anticipate will result in a surge in domestic mining activity and productivity. Again, a lot of this sounds like EFS, and if you go into the CASH website and navigate that page a bit, you will see that one of the direct links they send you to is for EFS. So, right now it sounds good that they're trying to put these resources out there to help operators. But you hope that there's going to be the support and foundation on the back end, which we would need a lot of EFS people to be filled in those roles again for it to be built out. The other one is MSHA's Information Hub. This consolidated a lot of existing resources from MSHA into a single page. I think that's a very good thing. The MSHA website, it was not easy to find all the different tools and resources unless you were really familiar with that and spend a lot of time on the website, which not everyone does. So this is a good development, in my opinion, because it brings that information together, puts into a spot where you can navigate quickly to a lot of different areas. There's more than 30 topics linked on this page, and they go from policy and rulemaking guidance to data availability and even an Ask MSHA email that they link you to submit questions. So, that it's a good thing that they're starting to build out that information. I would like to see and hope that they kind of evolve this into a better system for submitting questions and developing guidance that all of industry can see and there's transparency in. I think that would be helpful from a consistency standpoint, as we mentioned earlier. But it's good to see that they are at least making active efforts to kind of become more transparent and give people better access to some of that information, because it was not always easy to find previously. On the rulemaking front, we continue to talk about silica. So silica, just for a reminder for everyone, the new standard was adopted in April of 2024. It became effective in June of 2024, and the final rule. And then MSHA put into place two compliance deadlines, one for coal and one for metal non-metal, that extended out essentially a year and 2 years from the date that it was published in the Federal Register. So that date was April of 2025, or April 8th of 2025 for coal mines, and April 2026 for metal non-metal mines. Now that was issued prior to the litigation where about 6 industry groups challenged the rule. That litigation is continuing. Right now, when we were rolling up to the coal deadline in April, MSHA issued a voluntary stay on enforcement to give coal more time to get into compliance. That stay was until August of 2025, a deadline which we've passed. But what happened in the interim is that the industry groups filed for a stay from the Eighth Circuit, where the court case is pending the resolution of that litigation, and that was granted. So that means that the rule is on hold right now until it is resolved before the Eighth Circuit, whether it's through some sort of settlement or through hearing and decision. So we will continue to kind of see what happens with that. There are active discussions between industry and the agency about how this rule may be modified in settlement, or it could go forward and be heard by the Eighth Circuit and ruled upon there. At that point, the Eighth Circuit can either uphold the rule as written by MSHA, and it would go into effect pending challenge before the Supreme Court, or they could vacate the rule. Again, MSHA would have the ability to appeal there, or they could remand the rule back to MSHA for further consideration, essentially reopening the rulemaking process. And so really there's a number of ways that could go right now. A lot of the issues that are really the core of that challenge are some of the more onerous elements of the rule. So the prohibition of worker rotation, the prohibition of use of respirators for compliance, mandatory medical surveillance for all personnel, not just those who have hit an exposure or threshold level, reporting results to MSHA automatically if you're over the Pell, and they have the ability to enforce if you do that. Those are a lot of the elements that industry is dialed in on in terms of the challenges. And really, if you look at it, those are a lot of the elements that are different than the OSHA rule that came out in 2016. And so, in settlement, maybe that's a way that we can push as an industry is trying to get something more aligned to the OSHA rule. I think that's an idea. But even if that was the case, we'd still be looking at probably a Pell of 50 micrograms and an action level of 25. So, we'll see what happens as we move forward, and we'll keep you guys up to date as this develops and as there's anything new to report. But right now we are still dealing with the same rule, pending changes. There is a stay. So if we get to April of 2026 and it's not resolved and it's still before the Eighth Circuit, it would not necessarily go into effect. We think it's still, and what we're telling companies is you still probably want to find out and do some testing about where you might have issues, where you might have hot spots, and start, game planning what you can do around those, because that Pell and action level, it's very likely that, unless this is just vacated and MSHA doesn't take up the rulemaking again, that they could, we could see those Pell and action level remain. But so looking at it now and looking if you can find out, do you have an area, do you have a practice that is really going to be an issue for you, and then you can look at what your controls might be and what you might do there. But for now, we're in a little bit of a wait and see period. And if you guys have more detailed questions about that, obviously we've done a number of webinars on that standard and have published a number of blogs and descriptions of it as well. So we're happy to dive more into that with detail with you individually if you have questions on it. The other aspect that MSHA has been pushing forward on is some proposed rulemaking, which might be a surprise because, right, the deregulatory agenda was a big part of the Trump campaign. And this is the deregulatory agenda, but it is going through proposed rulemaking in order to get there. And part of what is happening now is the Trump administration flagged they want a 10-to-1 deregulatory ratio. This time around, that would mean 10 regulations either rescinded for every new regulation there is. And what some of the agencies are trying to do there is work on modernization and rescinding regulations by getting rid of standards or rules that are no longer applicable, maybe because they're outdated, or by getting rid of duplicate regulations. And that's some of what we're seeing here in these different areas. So, there was 18 proposed rulemakings that MSHA put out there. We're not going to cover all of those in detail for you, but we'll go through some of the highlights on them. One of them, which is very interesting, is that MSHA is proposing to eliminate district manager authority to require anything in a plan that is not independently required by a statute or MSHA standard. Right now, district managers have the ability and authority to approve or deny and require additional elements to be included in roof control and ventilation plans or training plans if you're Part 48. And this often is a source of frustration, especially on the Part 48, where from district to district, the same program might receive different feedback, and then not be the same program anymore. So this is really an interesting thing that we're seeing from MSHA. It's hopefully going to result in greater consistency, but there's a constitutional challenge to it, which the agency is clearly recognizing and trying to get ahead of. But they're seeing that there might be far too much authority or discretion offered to people in these roles who are not appointed as required. So that's an interesting one, and we'll see how that kind of evolves as it moves forward. But in our view, it's not necessarily a bad thing to potentially centralize those kinds of approvals at the national level and create greater consistency across the country there for you. Another one would be the use of PAPRs or electronic surveying equipment in underground operations. So these are typically have not been permitted in this unless you had a petition for modification. So this would allow you to move forward there. And then with HAZCOM, operators will be able to provide hard copy or electronic versions of those materials moving forward. So not really seismic shifts, but really kind of updating and modernizing standards a bit there. Additionally, in diesel particulate matter, MSHA is looking to revise the standards that are related to metal, non-metal, and coal. Really, these would be essentially eliminating provisions of the rules that were allowing for phased in compliance with the current regulation and the current permissible exposure levels or the current emission standards. And these revisions for both metal, non-metal, and coal really just get rid of some of those onerous parts of the rule that allow you to comply with a certain level for this period of time because that time has passed, and they're setting the standards at what they are currently under the regulatory scheme based off past rulemaking. Additionally, the same thing happens with approved conveyors and underground coal mines. This just is going to require all conveyors to be approved under Part 14. And that is, again, removing some of those elements that were allowing you to comply under different areas or sections while you were coming into compliance with Part 14 over time. And so really not much of a change for industry, just streamlining what those regs say. And then lastly, the one that we'll highlight is a discussion on drill equipment and area inspections. So those are metal non-metal standards, which required that you remove a drill from service if a defect is found, and you inspect the area around the drill before it is actively worked in. Obviously, those both have other standards which apply, whether that's the pre-shift mobile equipments under 56 14-100 or workplace exams under 56-18-002. So really areas, again, where we maybe had some redundant regulation, and this is allowing us to kind of streamline that. So a bit of the deregulatory agenda in a way that, MSHA argues does not decrease the safety and health of the existing standards. And one of the reasons they argue that is because there is a provision of the Mine Act that says that no new standard or revision shall be less protective than what was already in existence. So that is kind of the issue that MSHA is going to deal with there. I think it's probably hard to argue on some of these that there's going to be any less protection, which is what MSHA is hoping for. These were, for the most part, very much straightforward revisions there. But with that, I'll turn it over to Emily, and she'll go ahead and take us through some updates on decisions and the Federal Mine Safety and Health Review Commission.
Thanks, Nick. So let's get into it. Just a quick primer on the commission, or FMSHRC, as we, well, I guess unfortunately call it, given that acronym. But the commission was established at the same time as MSHA in the 1977 Mine Act, but of course it is an independent agency. It is totally separate from MSHA, not controlled by the Department of Labor, and its job is to adjudicate challenges to MSHA enforcement actions. So citations, orders, penalties in various ways can be put into contest before the commission. So we're going to talk about the state of the commission right now and some recent decisions that have come out and some trends that we're seeing and issues to watch. So first, let's talk about the current composition of the commission. The commission has 5 chairs to be filled with up to 5 people. In the past couple of years, it hasn't usually been at its full complement, and that's what we're seeing right now. Right now, the commission has 3 active members. They are Mary Lou Jordan, Timothy Baker, and Moshe Marvit. The commission, or the chairs of each member of the commission, are on staggered terms. So when some terms expire, you'll see like new commissioners being nominated by the president and confirmed by the Senate, or sometimes existing commissioners being renominated to the chairs that they just kind of vacated. So as you can see from this slide, we have 2 commissioners whose terms are expiring next August, and 1 commissioner whose term is not expiring until 2028. So assuming these commissioners stay in place, which we can talk about a bit more in a few minutes, we wouldn't anticipate seeing anybody leaving the commission, at least for probably the next year. Marko Rakovic, who formerly served on the commission in the first Trump administration and through the Biden administration, has been renominated back to the commission. Similar to Wayne Palmer, his nomination has been reported out of the Senate Help Committee, and he is just awaiting a vote as well. And I also, much like Wayne Palmer, do not think there will be much of a question that he'll be confirmed for that spot. Historically, although this isn't required by the statute, the commission tends to be populated by 3 commissioners who come from industry background and 2 commissioners who kind of come from a labor background, or vice versa. Right now, the commission is made up of 3 members who come from a labor background. and that's Jordan, Baker, and Marvitt. So right now, the commission's composition is pretty favorable, at least in theory, to what MSHA is doing. And that's something that we'll certainly keep in mind as we talk about potential trends and issues to watch. That being said, as folks who are reading the news are no doubt aware, there are lots of government changes and constitutional challenges kicking around out there in this sort of legal world that may affect the commission. So I thought we'd just briefly talk through what some of those might be. One of them is presidential control of independent agencies. So as I said a few minutes ago, the commission is not actually like a cabinet agency in the sense that the Department of Labor is. So the commission doesn't work for the president in the same sense that, for example, the Secretary of Labor does. But the president earlier this spring signed Executive Order 14215 entitled Ensuring Accountability for All Agencies. And the general thrust of that executive order is to assert more control over independent agencies, which Congress has set up to be more independent from the executive branch than the actual kind of traditional executive branch agencies like the Department of Labor. Importantly, for our discussion of kind of the legal aspects of cases and decisions from FMSHRC, that executive order says that the Attorney General and the President, not the independent agency itself, say what the executive's interpretation of the law is. And that executive order prohibits independent agencies from taking any legal position that is inconsistent with what the president or attorney general tells the agency that it can take. So it will be interesting to see how this may or may not affect the commission's decision making. We'll talk more in a few minutes about some of the cases that are pending right now and how this potential kind of restriction on the commission's ability to disagree with the Department of Labor might affect those cases. So that's certainly something to keep in mind. Another big issue that's kicking around out there is the Seventh Amendment right to jury trials. So you may have heard last year the Supreme Court, in one of several big blockbuster administrative law decisions, issued its decision in a case called the Securities and Exchange Commission v. Jarkissi or Jarkesi. I wish I knew how to say it, but I don't. In any event, that case involved a challenge by an investment advisor to the SEC's kind of adjudicating an enforcement case against him in an administrative court. And the Supreme Court agreed with his challenge and said, no, that enforcement action that the SEC brought has to be brought in federal court because the Seventh Amendment to the Constitution gives you the right to a jury trial on kind of claims at common law. We are seeing similar arguments being raised across the country in very, very many administrative contexts. We've seen them in FDA, obviously the SEC. Significantly, there is a case, I believe, in New Jersey by a steel company challenging OSHRC on these grounds. And we are also seeing these challenges being raised at the ALJ level before our commission, at the commission level itself, and even in the federal courts of appeals. There's at least one case pending in the Eighth Circuit right now that's raising these types of arguments. We have seen one commission ALJ, I think, reject these arguments, but that's the most that I've seen. Nick, if you have seen something else, please hop in and correct me, obviously. But we have not seen FMSHRC itself weigh in on this issue, nor have we seen a court of appeals. So it will be interesting to see how either the FMSHRC challenges along these lines play out or the OSHRC challenges, because OSHRC and FMSHRC are so similar that what happens to one is very likely to affect what happens to the other. So definitely something to watch there.
Yeah, and then Emily, I'll just jump in there. I know, I mean, you're obviously stating what I've seen as well in terms of with FMSHRC, but I think this Kendrick Steele case with OSHRC is very important to watch as we push forward. I mean, it might, I think that everyone kind of has different opinions on this, what is whether it's a good thing or a bad thing. I will say we do get, there's often frustration with dealing with these review commissions because they are much more lax in sometimes how they go and the deference they give to the agencies. But they're also, you know, an educated body that hears these cases all the time. So we, you know, have the benefit of an adjudicator who is not learning this for the first time. And sometimes it works to our benefit as an operator challenging an issue, and kind of can help us get to that really core issue maybe much easier and much more quickly. So definitely one of those challenges that is interesting to watch, and certainly has a lot of implications, both that some might consider positives or negatives, depending how they shake out.
Certainly agreed. And then, you know, another issue that's coming up that I think we can cover pretty quickly are issues of removal protections, both for the commissioners, those 5 folks that we talked about, 4 that we talked about earlier, and then for the administrative law judges who are kind of underneath them. The Mine Act, as well as many, many, many other federal statutes that create agencies like the commission, kind of insulate the members of the commissions from being fired at will by the president. So the Mine Act says that commissioners can be removed by the president for inefficiency, neglect of duty, or malfeasance in office, but not because the president disagrees with them. The president has removed many, well, not many, but some members of other agencies that are set up very similarly to FMSHRC. And the Supreme Court has so far allowed those to stand. Of course, those are preliminary decisions. They haven't been fully gone through the litigation process. But for now, the Supreme Court has allowed those to proceed. The president has not removed the members of FMSHRC. But, you know, that's certainly an open question about whether that might be on the table. And then with respect to kind of removal protections for the ALJs themselves, even the Department of Justice has taken the position that, you know, the statutes that kind of protect the ALJs from removal by the commission, which is itself protected from removal by the president, are unconstitutional. So it wouldn't surprise me to see a world where ALJs may not enjoy quite as much protection from removal as they enjoy now. So that's kind of where we are with the general constitutional issues that are kicking around out there that are, you know, coming up at various stages of litigation, and certainly, I think, affecting how anybody who practices before the commission is thinking about kind of how to go about practicing before the commission right now. But let's get into some cases then. So I wanted to talk about a couple of, or one decision and one pending case covering the evergreen topic of MSHA/OSHA jurisdiction and its many fun flavors. So in 2023, the Sixth Circuit Court of Appeals issued a decision in a case called Jones Brothers. This was an interesting decision because it's the first decision from a court of appeals on what constitutes a mine versus what constitutes a borrow pit. So MSHA and OSHA have an interagency agreement, sometimes called the Memorandum of Understanding, or MOU, which lays out or attempts to lay out kind of the lines between MSHA's jurisdiction, i.e. a mine, and OSHA's jurisdiction, not a mine. This is not always super clear in practice, as we will see, but at least theoretically, the MOU helps govern what MSHA is doing and what OSHA is doing. One of the things the agreement talks about is what constitutes a borrow pit and not a mine. It lays out 5 factors, each of which has to be satisfied for the operation to be considered a borrow pit and thus OSHA's jurisdiction. So that's overburden is extracted. The extraction is, you know, intermittent, one time only. It's used more as fill and bulk than for its intrinsic qualities. It's not milled except for a scalping screen, and it has to be extracted near the area where the fill is to be used. So Jones Brothers involved an extraction operation in contract with the Tennessee Department of Transportation to repair a road. Jones Brothers needed graded solid rock to fulfill its orders, and TDOT had specifications for size, hardness, shape of the rock, and it also required Jones Brothers to use an acceptable screening process to make sure that the rock would meet its specs. So Jones Brothers signs this agreement with TDOT and then obtained the and then it started actually removing rock from the area, screening it, and getting it ready to move to the road site. About 8 months after it had begun that process, MSHA came by and decided it was a mine and issued several citations and orders. After some twists and turns on unrelated constitutional issues, the issue of whether it was a mine was finally decided. The commission ALJ said, yes, this operation is a mine, and the Sixth Circuit affirmed. The Sixth Circuit highlighted that, again, all 5 of those factors in the interagency agreement have to be met before this operation can be considered a borrow pit. And here it focused on 2 that were not met. The court said extraction was not one time only or intermittent, because in this case, Jones Brothers was like not continuously, but had gone back to extract materials very frequently. It had been ongoing for several months. I think it had extracted about 70,000 tons of stone. And so the court says, no, that's not intermittent or one time only. And the court also emphasized that although, you know, the rock was used in part for its fill, there was also more for its intrinsic properties related to drainage and strength than just for its bulk. So the court said, no, you only met, you know, you didn't meet these 2, therefore you can't be a borrow pit. And yes, we're going to agree that that's a mine. You know, I think this highlights, and Nick, you can hop in here too, that jurisdiction questions are extremely fact specific, and the, you know, factors that are laid out in the MOU are not necessarily always easy to apply. And so, you know, folk or operators who are setting up new operations, changing their processes, especially if they're engaged in the processes that may constitute milling, you know, that's a good opportunity, I think, to rethink whether your operation is MSHA or OSHA jurisdiction. And because it was one or the other does not necessarily mean that it's always going to be one or the other. And so, you know, if you are, again, changing your operations or beginning a new one, that it is an excellent opportunity to reach out and, you know, have a discussion about, is this OSHA or is this MSHA? And what the, you know, advantages and disadvantages to being in either regulatory regime may be.
Yeah, Emily, I think that's exactly right. And I think you'll touch on this on the next slide as well. But I mean, I think the other part is, if you have a concern related to jurisdiction, you need to act on it quickly. You know, you cannot sit there and accept citations and accept as for enforcement from either agency, MSHA or OSHA, over a site that you think is not in the proper jurisdiction, because that'll be used against you as a somewhat accepting that control by the agencies. So if these concerns do come up, you do have to challenge them immediately. And you know, ideally, you're doing so outside the context of litigation, right? We're identifying these and getting on top of them and having negotiations with the agencies informally. But if the litigation does have to happen, that you don't miss any opportunities to do that by just paying a citation because it's a, you know, $200 citation, but it claims jurisdiction to one agency or the other, and you disagree with that.
Great points. So now let's talk quickly about an important case to watch, also on jurisdiction, called KC Transport. This case is about whether kind of off-site facilities, repair shops, maintenance shops count as mines, or whether they are not mines and therefore are subject to OSHA's jurisdiction. So KC Transport is an interesting case. It arose in a holler in West Virginia, which I'm allowed to say because I live there and grew up there. There were several coal mines up this holler. It was gated off by a private security gate, but off the kind of mine road that connected these extraction sites to the prep plant, which was also behind the security gate, a couple hundred yards off the road, there was a maintenance facility that independent contractor KC Transport was using to work on haul trucks and other trucks. And MSHA went to this facility to actually terminate citations it had issued to some coal haul trucks that they had been cited while they were at one of the extraction sites. But while at this maintenance facility, MSHA issued other citations, and the operator challenged those citations, saying, hey, trucks are not mines. A commission ALJ said, I agree, these trucks are not mines, but the facility itself is a mine. And then the commission itself said, no, neither the trucks nor the maintenance facility is a mine. And the commission was following a 2017 decision from the Sixth Circuit. So if this sounds familiar, that's probably why. This was a case called Maxim Rebuild, where the Sixth Circuit said, offsite facilities, offsite maintenance shops are not going to be, in most circumstances, mines. That's because coal or other mine, as defined in the Mine Act, is kind of on, above, beneath, or pertinent to active mines. So on or adjacent to extraction sites or mine roads. If it's not that, it's not a mine. The secretary appealed that commission decision to the DC Circuit. The secretary's position there was that both the facility and these particular trucks met the definition of mine. There was kind of complicated proceedings at the Court of Appeals. The case went up, or the DC Circuit initially said, well, we think the commission's wrong, but we're not sure if MSHA's right. So we'll send it back and let MSHA explain some more. But then the operator went to the Supreme Court, and the Supreme Court sent it back to the DC Circuit. So there's been definitely some convoluted litigation here. But we're waiting at this point for the DC Circuit to issue its decision and explain whether the commission got it right, whether the MSHA's got it right, or maybe it'll do something different. So we'll certainly be watching with great interest to see how that case comes out, because it will likely set up, well, if MSHA wins in some respect, it will likely set up what's called a circuit split with the Sixth Circuit, and that is Supreme Court catnip. So I think it is very likely that if MSHA does win, that KC Transport will probably go back to the Supreme Court to seek review. Now, the Supreme Court obviously doesn't take many cases, so that works against Supreme Court review, but like I mentioned, they do take circuit splits. So if you do have the courts of appeals disagreeing about an issue, the Supreme Court will sometimes step in. So we'll certainly be watching this one to see how it shakes out, because it's got obviously enormous implications for folks who have maintenance shops close to, but not on, extraction sites or roads. So definitely this is one to watch. And then I think we'll try to move a little more quickly here through some of these others. Another big decision that came out recently from the Court of Appeals, this was an Eighth Circuit case. It involved important issues on reckless flagrant violations and also 110C liability for agents of corporate operators. This case involved a walkway at an iron ore processing plant. The walkway had deteriorated over the course of many years. The operator had obtained an engineering report, which essentially said this walkway is not suitable for use by humans, but fall protection was provided and miners continued to use the walkway. Part of the walkway fell out from underneath a miner, and the miner was injured, but wearing fall protection, so thankfully not killed. MSHA issued a couple citations or orders, including one that was designated as a flagrant violation, which means that the maximum penalty is significantly higher. I believe last year was about $220,000 as opposed, or around $200,000 as opposed to about $74,000 for a non-flagrant 104D. So a major financial difference there in the penalties. In that case, the commission said, yes, we have violations, but we don't have a flagrant violation, because a flagrant violation has to be like super reckless. The Eighth Circuit disagreed with that and said, no, there's not kind of heightened recklessness for flagrants. Instead, the test is just if a mine operator knows or should know to ameliorate a known violation, but fails to make reasonable efforts, then potentially you've got recklessness for the purposes of those heightened penalties. In the first Trump administration, very few, if any, flagrant violation or flagrant penalties were assessed. So this may not be an immediate, for the next couple of years, concern for folks. And hopefully, obviously, no one will be in a position to be looking down a potential flagrant violation at all. But certainly, if another administration comes in that takes a different view of this enforcement tool, this is something to keep in mind for sure, because it does establish a lower bar for the agency than the commission would have set. And similarly, the Eighth Circuit also kind of rejected the commission's approach to 110C liability in this case. MSHA had assessed penalties against 2 agents of the operator These agents were, your quintessential, like, safety superintendents, guys who had supervisory responsibility at the site. The commission said, well, these two individuals can't be held liable as agents because they didn't have the authority, or they didn't have the ability to remedy the specific violative condition. For example, they weren't actually allowed to spend money to get this repaired or to prohibit access to the area. But the Eighth Circuit said, no, that's too narrow. 110C has to focus on other factors, such as, what actions they took, whether they engaged in aggravated conduct, and whether they had sort of this authority to act on safety and health generally. So there you see the Court of Appeals kind of broadening these important definitions on recklessness and 110C. And another decision we just wanted to quickly highlight, although like reckless flagrants, it may not come up immediately, is a decision from the commission last year in the pattern of violation context. This case came up after MSHA had issued a POV notice to a salt mine down in Louisiana. Morton Salt challenged the POV designation before the commission, and the commission judge seemed inclined to allow the commission to kind of look behind why MSHA issued the POV notice to the mine in the first place. Because the way MSHA's regulation is written, it lays out several factors that MSHA will consider. And it says MSHA will also look at mitigating circumstances, but ultimately this is kind of just up to MSHA. So MSHA appealed that case to the commission and won before the commission. The commission held that MSHA has unreviewable discretion to issue a pattern of violation notice to a mine. That means the commission can't review it and the courts can't review it. So if MSHA issues a POV notice to a mine, there's really not much the mine can do. Now, of course, ultimately, MSHA does have to prove that there is in fact a pattern of violations, but the actual fact of issuing that notice, which is of course necessary to trigger the actual withdrawal orders under the POV provision, which is section 104E of the Act, that is unreviewable. So again, there were no POV notices issued during the first Trump administration. This may continue to be the case for this Trump administration, but certainly this was a big win for MSHA's authority in this area for the future if it wishes to exercise that authority. Just a couple more to move through quickly here. This is a topic that I imagine folks are familiar with at this point because the issue of settlements and FMSHRC and MSHA has been a lively one for several years running now. But procedurally now, these settlement cases, as we're going to shorthand them here, are in a different point than they have been before. So the commission at this point has held that in the context of settlement, MSHA does not have unreviewable authority to vacate a citation or to remove an SNS designation. Instead, FMSHRC has to approve that, which means that MSHA's got to give reasons that it did those things to the commission's satisfaction. MSHA disagrees with that ruling and has appealed several cases to the DC Circuit Court of Appeals. Those cases are pending. A decision is probably likely to come next year. The court seems kind of interested in some ancillary issues, including like whether it can even hear the appeals. So it'll be interesting to see how this one plays out. But whichever way it's decided, it's going to potentially have major implications for parties' ability to settle cases before FMSHRC, which, as I imagine most folks on the call know, is not always the easiest thing to do anyway. So that's certainly another set of cases to keep your eye on.
Yeah, and I'll just add there, this is one of those instances that we've dealt with throughout these settlement cases between MSHA and FMSHRC, where oftentimes, right, as the operator, we feel pretty good, right? We've come to a settlement with MSHA. Maybe we're ecstatic about it, maybe we're happy it's resolved and think we got a decent settlement there, but nonetheless, we've decided to be done with it and move on. And it can be a significant source of frustration when the commission doesn't let that happen between the parties. So we don't see it. We haven't seen it too often, but even just recently, Emily and I, we had a case where we had to provide, further justification in order to defend what we agreed to settle with MSHA. And so it is something that we do see. Hopefully we don't see it more often, but it is certainly a real challenge that is before us.
Certainly is. And then just a couple cases pending at the commission itself to keep an eye on. There's one case called Nally and Hamilton Enterprises. This is a case that came up after a fatal accident at a surface coal mine. A pickup truck was traveling past a high wall, and a tree that was on the edge fell and crushed the cab. MSHA issued a citation under section 1713A for failing to conduct what was in effect an adequate kind of examination of the working place. The commission has held its open meeting earlier this year, February or March, I believe, and seemed to be toying with the idea that perhaps this accident kind of per se established an inadequate examination. Now, obviously, what the commission says when it's kind of kicking around ideas about how to decide a case is not what it's going to say when it ultimately decides the case. But obviously, MSHA often cites the workplace examination standards, whether that's coal surface, coal underground, or metal on metal. It's very common to see an exam violation accompany, one violation, or especially if an inspector observes what they believe to be many violations during an inspection, it's very common to see an exam citation as well. So what the commission says in this case could have big implications for how MSHA cites alleged exam violations in the future. And another case pending with FMSHRC is Cactus Canyon Quarries. This features another perennial favorite, the 15-minute reporting rule for injuries that have a reasonable potential to cause death. This case involved a roof burst in an underground coal mine that covered a miner in coal. I can't remember exactly how much coal it was, but I believe hit the miner in the head. There were questions about the severity of the miner's injuries, but it wasn't reported to MSHA, and MSHA issued a citation for the 15-minute reporting rule. We see these cases come up in many, many, many factual contexts. The commission decides these cases pretty regularly, and yet there continues to be kind of a frustrating lack of clarity on what exactly it means to have a reasonable potential to cause death. And the development of this law kind of piecemeal, case by case by case, is perhaps not providing as much clarity as really would be ideal. And we'll have to wait and see whether this is the case where the commission attempts to provide more clarity. Whether the commission succeeds in providing more clarity, I think, is not at all a given. But this is also an issue that affects many, many mine operators out there, and especially is important because it does come with a statutory minimum penalty that is significantly higher than the statutory minimum penalties for other violations. So this is an area where I do think that it would be great to get more certainty. Whether that comes from MSHA or comes from the commission through litigation, I don't know, but it would be great for all parties, I think, to have that clarity. So hopefully during the next couple of years, we can get that. And then finally, just a couple thoughts on issues to watch as we move through the next 3.5 years of the first or the second Trump administration here. Obviously, there's going to be there are issues about 105C cases going on, temporary reinstatement. We've seen some constitutional challenges raised by operators in TR cases recently. At least one commissioner thinks the commission actually can't reopen final orders, which are, for the most part, assessments not contested within 30 days. So there's potentially big issues kicking around out there. And as with most things commission-wise, there's not much to do but wait and see. So thanks, Nick. I'll kick it back to you.
Thank you. Thanks for that, Emily. Yeah. So, obviously there's a lot that is, percolating, and we'll continue to see how that shakes out. I'll just add to the last case that Emily was discussing with the immediately reportable question. That's one that continues to come up. We are seeing a little maybe movement, or at least an interest in trying to get some more clarity there. And it's something that we've certainly tossed around as part of our MSHA modernization thoughts in terms of what we can maybe press this administration to get into place to further those other proposed rulemakings. But, if you have situations pop up that, you don't think was really, or was an instance that would really qualify for that, but you were still cited by MSHA, don't just take it as an automatic, right? There is an opportunity to challenge that as well. And you should try and at least get that clarity as we push forward, because that's something that we as an industry just continue to seek there. I want to thank everyone for joining us today and for staying a few minutes over with us. We just want to let you all know that we continue to have a couple more webinars scheduled for this year on the MSHA front. Our next one being in September, which is a crossover webinar on protecting your interest during workplace crisis management with our OSHA webinar series. So feel free to join us for that one. We hope you can, and continue our discussions. As always, we'll do our best to keep you up to date through our various blogs that the firm has. One OSHA, MSHA, or Cal OSHA and Labor and Employment Matters. So check back there, or feel free to reach out to us at any time if you have any questions. I will just give one plug that if you're on the West Coast, this October we will have two separate in-person events in California, and one in Southern California and one in Northern California for our Cal OSHA practice, and specifically looking at Cal OSHA and our California Labor and Employment Law Summit. So if you're interested in that, welcome you to scan the code and get some additional information on it, or feel free to reach out to us and we can provide that. I'm not seeing any questions here in the chat today, so we'll be looking for that if anything comes in at the last minute. But otherwise, Emily and I were happy to speak with you today. Thanks for joining us, and our contact information is on the screen. Don't hesitate to reach out to any one of us if you have follow-up questions on this. All right, thanks everybody. Have a great afternoon.